Intestate succession refers to the process under California inheritance laws that details what happens to a person's estate assets when that person dies without a last will and testament. Let's take a look. The Guide to Intestate Succession in California. California's inheritance laws are straightforward and dictate how a loved one's estate assets will be distributed after they pass without a will. And unlike a last will and testament or trust, which can be contested or challenged, California's intestate succession laws cannot. That being said, if you have a claim against an estate, separate and apart from what you may receive under California's inheritance laws, you may pursue that claim to try and recover your claim in addition to what you might receive under the intestate succession laws. You would be best served to retain a probate litigation attorney to advise you as to what your rights are and the best course of action. What is the definition and meaning of intestate succession? Intestate succession specifically refers to the order in which spouses, children, siblings, parents, cousins, great aunts and uncles, second cousins twice removed, etc., are entitled to inherit from a family member when no will or trust exists. For example, in California, if a married individual passes away without a will, their community property, that is, their assets acquired during the marriage that belong to the marital estate, such as earnings and income, will be distributed to their surviving spouse. If the individual also has separate property, one half of that property will be distributed to the surviving spouse if the couple has one child, with the child entitled to the other half of that separate property. The surviving spouse will get 1/3 of the separate property if the couple have 2 or more children, with the children getting the other 2/3. What assets are subject to intestate succession? California's intestate succession laws apply to your deceased loved one's estate assets. What does that mean? Estate assets include all the property owned by your loved one at their death, other than property held in a trust, like a family trust or a revocable living trust, property that is held in joint tenancy, like real estate or bank accounts, or property that has a beneficiary designation, like an IRA or life insurance. What are typical intestate succession problems? At RMO, we see most problems and conflicts occurring between the biological children of the decedent and a step-parent. For example, when the decedent was married more than once. In these situations, emotions often dictate, especially early on after your loved one has just passed. Many times, the children have difficulty accepting that the new spouse, their step-parent, should get anything, especially where there was friction between them and the step-parent during the decedent's lifetime, or if the marriage was new. A variety of familial situations and relationships can cause difficult emotional conditions that need to be addressed. The laws of intestate succession for heirs and beneficiaries according to the probate code. The state of California has clear intestate succession guidelines and processes for property distribution to a decedent's spouse, children, siblings, and living parents. Here are the basics. If the decedent created no will or trust and was married with no children, all assets are distributed to their surviving spouse. If the decedent created no will or trust and was not married, all assets are distributed to the decedent's children. If there's more than one child, then assets are shared equally among the living children. If a child predeceased the decedent, that child's children will take that child's share. If the child predeceased with no children, then the other living children will take that predeceased child's share. If the decedent created no will or trust and was married with children, then the decedent's community property assets acquired during the marriage are distributed to the surviving spouse. The decedent's separate property is distributed to the surviving spouse and the children, 1/2 to each if there's only one child, and 1/3 to the surviving spouse and 2/3 to the children if more than one child. If the decedent created no will or trust and has no spouse or children, then all the assets go to the decedent's kin or heirs based on the closest family relationship. First parents, then siblings, then cousins, etc. If the decedent created no will or trust and has no heirs or kin, then all of the assets go to the state. If this seems a bit complicated to understand, it's because it is. Just give us a call and let us know your situation. We're happy to answer your questions, and the initial consultation is always free. Can I contest or dispute intestate succession? The short answer is no. You cannot contest or dispute intestate succession under California law. That being said, there are claims that can be made that might help you obtain more than your intestate share of the estate. We can help you analyze whether you have a claim. Do I need an intestate succession litigation attorney near me? We recommend finding an experienced probate litigation attorney familiar with the county probate court in the county where the decedent lived. For example, if they lived in Los Angeles, we recommend working with a probate litigation lawyer in Los Angeles. A Los Angeles probate litigation attorney will generally be more familiar with the Los Angeles probate court than an out-of-state or out-of-area attorney. At RMO, we protect people like you every day. The consultation's always free. Give us a shout, give us a call, shoot us an email. We're always happy to help. Thanks for watching.